Hi, everybody. This is Tiffany. I am going to be talking about the competence to be executed and to participate and waive appeals. This was established with Ford versus Wainwright in 1986 with regards to the Eighth Amendment, which is cruel and unusual punishment. Ford versus Wainwright upheld a common law rule that the insane cannot be executed. They are entitled to a competency evaluation and to an evidentiary hearing in a court on the question of their competency to be executed. So there is not a set definition of competence to be executed. However, with help from the Eighth Amendment and Justice Powell's thoughts, quote, forbids the execution only of those who are unaware of the punishment they are about to suffer and why they are to suffer it, end quote. This has to do with the Eighth Amendment because it is cruel and unusual to sentence someone to death if they don't understand. So they need to know the why of what's going on. Most states have similar standards to the above statement of competence and execution, but not all of them. So the American Bar Association, ABA, and American Psychological Association, APA, is aligned with the competency and execution definition. The ABA discussed the offender should have more than a superficial understanding of the reasons for their execution, but rather should deeply grasp why society has chosen the most severe penalty, death. So Panetti versus Quarterman, 2007, stated the Supreme Court decided that criminal defendants facing death sentences cannot be executed if they lack the understanding of the reasoning behind their execution. And once the state has scheduled an execution date, individuals on death row have the right to contest their competency for execution. So Panetti, he understood that he would die due to his death sentence. And the reason was due to his capital murder charge. So he murdered people, so he knew he was going to die. However, he believed the reason was due to his religious preaching. So it could be mental illness, deficits, whatever it is. He was found incompetent. So, per Melton, a person can still be incompetent if, quote, his awareness of the crime and punishment has little or no relation to the understanding of those concepts shared by the community as a whole, end quote. So the Panetti case helped define execution competence, and the Ford case serves as a benchmark for the court's protocols and assessing competency. So this is further ruled by Jackson versus Indiana, 1972. The Supreme Court found a U.S. state, Indiana, violated his constitutional rights by involuntarily institutionalizing a defendant for an indefinite time due to permanent incapacity to stand trial. So this also happened in Ryan versus Gomez, was ruled in this favor. The court stated where there is no reasonable hope of competence, a stay is inappropriate and merely frustrates the state's attempts to defend its presumptively valid judgment. So to tie it all together, one cannot stay in prison, death row, a facility forever if they are not competent. They have to have something else for them. This does not apply to those that are considered dangerous and incompetent, though. That is a separate thing outside of this. So if the defendant is competent to waiver his or her appeal, it is supported by the court, but it needs to be knowing and intelligent. So in summary, a defendant has to know and understand the importance of that decision and believe it. So the why, it's crucial to the understanding of it all. So evaluation issues. There are three big issues that they talked about. Counsel states that their client is not competent. The accused chooses to relinquish their right to post-conviction hearings, again, against their counsel wishes. And at the time of execution and the death warrant is signed, what is the defendant's competence status? So there are at least two structured professional assessment instruments that can help the clinician. There are three sections to each instrument that help the professional to evaluate an inmate's competence. So the understanding of what is about to happen, the execution, the why, their convicted crime, and their capability to aid their counsel. The third one is a big one, their capability to aid their counsel. While there are other questions and leading sentences that kind of help the first two, the last one, to aid their counsel, really doesn't have anything to support getting more information. So the first tool is Ebert's competency to be executed rating instrument. There are 12 items to this, 8 questions pertaining to practical legal skills and 4 clinical questions. The 8 questions for the legal skills are pretty straightforward. Per Melton, here are some examples. So awareness of punishment, what is about to happen, understanding the sentence of death, and understanding the concept of punishment. Additionally, there is a rating scale that helps to determine a degree of impairment incapacity rating. It's on a 5-point scale: 0, no incapacity, to 4, which is severe. The second one is the interview checklist for evaluations of competency for execution. This checklist has the same questions as Ebert's tool, however, it goes into greater detail. This checklist can be found on page 193 of Melton's book. It was very interesting to kind of look at the questions to see what would be asked. There are 4 parts to the checklist. Part 1 is understanding the reasons of punishment. Part 2, understanding of the punishment. Part 3, ability to appreciate and reason in addition to simple factual understanding. And part 4, ability to assist the attorney. So there's no rating scale for the checklist, but most likely most clinicians probably use something like Ebert's scale to help them kind of facilitate it. So even though there are issues with the 2 tools that were being discussed, that is more in the book that I didn't get into. Both help professionals get a better understanding of a defendant's impairments. These tools should not be used alone, but in conjunction with other clinical assessments or interviews. The interview should gauge emotional, behavioral, and mental functioning. There should be multiple visits if possible, and in a setting that is beneficial to the assessment. So this came out of Hayes versus Murphy, which requires interviews somewhere other than death row. Other sources can be considered healthcare records, interviews with other people, but only if necessary and that they speak to the current functioning. They don't want a lot of history. So the treatment issues with this, obviously, is the National Medical Association, NMA, states that treatment should always be provided, regardless of the status of legal circumstances. However, some argue that prisoners should have a say if they want treatment or not. So Perry versus Louisiana is an example of this. Perry was sentenced to death, but he was found incompetent unless he was on medication. He received a court order for involuntary medication to guarantee his competency. The court order was considered medically appropriate due to his danger to other status. So this was upheld. Louisiana Supreme Court concluded that making someone take medicine to make them competent to die was not permissible. 2 state laws actually supported this. One stating medicating someone who does not want it is cruel and unusual, which goes against the 8th Amendment, and it violates their privacy. So Sell versus United States found that defendants have the right to refuse medication if they are not dangerous, competent to make treatment decisions, and the charges against them are not serious. So a case study that goes into this is Madison versus Alabama for 2019. Vernon Madison shot a police officer, Julius Schul, 2 times in the back of the head in 1985. He claimed it was self-defense. 3 trials were held. The first one was overturned. Black people were purposely excluded from the jury by the prosecution. The second one, evidence was not introduced properly, again, by the prosecution. And the third trial, he was actually found guilty. The jury sentenced him to life in prison, but the judge overruled him and sentenced him to death in 1994. So in November 2017, the support court overturned his execution because in 2015 and 2016, Madison suffered severe strokes resulting in vascular dementia, which caused problems with judgment, memory, decision-making, and he actually couldn't remember the murder of Mr. Schulte anymore, but still understood that he was going to die for committing the crime. So even though he didn't remember committing his crime, committing the murder, he understood that his death sentence, that he had a death sentence and that he was going to die because of it. So therefore, he was actually found competent to be executed. He died in 2020 before his death sentence was carried out. I have included the link for the YouTube video here, and I'll put it in Canvas as well. It is a 12-minute video, so it's optional, but it does a great job explaining the whole case, and it kind of talks about the defense standpoint and where it came from. So, a discussion question that made me think about a lot of this is, do you think someone should be forced to take medication to make them competent for the sole purpose of execution? Is it better for someone to not understand what is coming? And should it differ for intellectual disabilities since you can't take medicine to make that better? Why or why not? Here are my references for my presentation. Thank you so much.